I'm Drew Stevenson, and this is a lecture for my Law and Economics seminar about tort law and economics. And in this video, I'm just giving a quick overview or introduction to some of the ways that we apply economic insights and principles to the area of tort law. I'll probably make separate video lectures or do some classroom lectures on each of these topics individually. And similarly, we're going to have a different unit that we do that's the law and economics of contract law or the law and economics of criminal law and so forth. So that being said, let's take a look at some of the general ways in which we're going to apply economics or economic analysis of the law to torts. So in your first year torts class, at some point, you probably encountered the hand formula, and that's this little algebraic formula that you see here. B is greater than or less than LP. And I'm going to have a separate video lecture just about the hand formula, but this is definitely a big area for law professors to talk about with tort law and economics. We also are going to talk about the best cost avoider, sometimes called the least cost avoider, and I have a separate video just about that. Externalities are a big area for us in tort law and economics, and externalities are basically the costs of our activities or our consumption that we don't internalize ourselves. Instead, we kind of foist it on innocent bystanders. The classic example is pollution, right? So you have a manufacturing plant and you don't want to spend the money to dispose of your hazardous waste responsibly, so you just dump it in the local river where it ends up in the water supply. So you saved some money, but you have now externalized those costs or harms onto other people. For a lot of students in either your torts class or property class, or maybe both, you heard something about the Coase Theorem. And we're going to have a unit where we talk about the Coase Theorem, thinking, and this is really about transaction costs. But the idea is that if the parties can have low transaction costs when it comes to bargaining or bargaining around the law, then it doesn't really matter how the law initially assigns rights or duties or responsibilities if the parties can basically negotiate and buy each other out. The world will end up the same way. So if you think about it, you could, one of the cases that comes up a lot in law school courses with the Coase Theorem is where you have a cement plant that's causing a lot of pollution, and the local homeowners who were there first sue the cement plant. But the cement plant is actually so profitable, it's much more profitable than the value of all of those homes put together. So they're able to just buy all of those people out of their households and pay them off and continue production at the plant. And even though the homeowners, in theory, according to the legal rules, would have had the right to get an injunction to stop it. Another topic that we talk about that is sometimes new for students when you get into your second or third year of law school is to talk about the social costs of accidents. So in our first year torts classes, we often present individual cases where you have a tortfeasor or the wrongdoer and a single injured victim or a group of identifiable victims who were hurt in an accident, let's say, or defrauded or slandered or something like that. But there are also activities that pose larger social costs. So some of the costs of, let's say, a person being injured in the accident are internalized by the victim himself or herself, right? Medical bills and the loss of productivity or loss of functioning if you receive a permanent injury. But there's also a bigger cost to society sometimes of the loss of a productive worker or the need to have more accommodations in public places and things like that. So sometimes if we step back from the individual tort case, there's a lot of social costs that aren't truly accounted for just with compensating the individual victim. And then another big area that we're going to talk about in my course is some insurance concepts with moral hazard and adverse selection. Again, some of my students have probably encountered these before, and for some of you, these will be new, but these are really useful ideas or analytical tools when we're analyzing the law. Now, in a first-year torts class, you learned the doctrine, but we're going to go beyond the basic doctrine that you needed to answer your final exam questions. So as a quick review, I am sure that you learned about duty and breach and causation and damages almost as elements of a tort claim, at least in negligence. You probably also learned the basic idea of strict liability versus negligence versus immunity from lawsuits, right? Which is sort of the opposite of being strictly liable for harms. And so but in my course, we're going to talk about this as sort of a continuum. And the fact is that a lot of cases are not completely in one category or another, but we actually have sort of a range of, for example, negligence duties and responsibilities and claims, or negligence liability. We have degrees of immunity from lawsuits and perhaps degrees of strict liability. And so we're going to talk about these instead of kind of a straightforward trichotomy. We're going to talk about it as a continuum, where a case is, where a lot of times we're moving the dial a little bit in the direction, say, between negligence and strict liability. You also probably learned about intentional and unintentional torts and contributory and comparative negligence. But we're going to talk about some of the economic arguments or insights from economics that we can use for why we would have certain rules under those rubrics. So your first year torts class introduces you to the sort of doctrinal ideas of the law. And here we're going to talk about some of the policy rationales, either for the rules that we have or that you could use to argue in an individual case that your client does or does not fit into one of these legal categories. And the same is true for compensatory or punitive damages, right? So you probably learned in your first year of law school that sometimes in a lawsuit, we're merely trying to make the person whole or put them back to where they were before, let's say, an accident or an injury happen to them. But other times we have exemplary or punitive damages. And as you know, there are some legal rules or boundaries for when you can and can't have punitive damages. But we are going to talk about some of the economic or policy arguments for why you would have that either as a general rule or in individual cases. I also want my students to kind of step back for a moment from the specific legal rules that you had to memorize in your first year class and even write about on your exam, and ask yourself, is our sort of tort policy, is the overall goal to reduce the number of accidents, in other words, to deter potential tortfeasors, or just to wait for accidents to happen and compensate the victims? And so is it a compensation scheme, or is it a regulatory or deterrence regime? Also, we're going to talk about in my course a little bit, or I want my students to think about the tort liability system of lawsuits and claims and compensation and verdicts and so forth versus safety regulations. So we could have a system where if you're injured at work, you sue your employer for having an unsafe work condition, or we could have a centralized workplace safety agency like OSHA that basically studies this. We hire some experts, they figure out what is safe and which types of safety measures or precautions in a workplace actually reduce the injuries or reduce the severity of injuries, and then just require employers to have those safety measures in place and fine them if they don't. And then we have a third system that we can compare with these other two, which is a type of insurance regime, a mandatory insurance regime, that's the workers' comp system. And this is where we make an employer basically pay into a victim's compensation pool. And when the worker is injured, they are going to get compensated out of the workers' comp funds in an administrative system instead of a regular tort liability trial. And the employer, the amount that they have to pay in to the victim's compensation pool in any given year is partly dependent on how many accidents they have. And so a safer, it incentivizes employers to be safe in their workplace so that they can reduce their workers' comp insurance premiums and so forth. And again, I mentioned this a moment ago, but we have along with our tort liability in the background, we have a very robust market or industry of insurance and liability insurance. And this in turn kind of functions as almost a privatized regulatory regime where your insurance premiums may be lower or higher depending on how many accidents and injuries or claims are filed under your policy, and how many safety measures you're in place. And so liability insurance in itself can create incentives for the people who own the policies, for policyholders, to take more safety precautions in order to reduce their premiums. And so one thing that economists will study is whether liability insurance is actually doing more than our tort liability in itself in making workers safe. Or if the tort system is the threat of lawsuits is necessary, basically a necessary antecedent to having liability insurance, which then comes through and basically prices the dangerousness of various activities, whether it's workplace activities or business activities or even recreational activities, or the activities that you do at home with your homeowner's insurance and so forth, that in the end, we're able to basically price this. This goes back to some of our ideas about externalities, and we're going to talk about moral hazard and adverse selection in regards to that. And that concludes my brief introductory lecture to tort law and economics. And there will be more videos about specific topics to follow.